Hello friends, in the series on the income tax cases, today we will discuss an issue which was really painful for the assessee, and the assessee has to fight a matter for prosecution for not filing the return of income on time for 44 years. This case gains importance in the light that the compliance part of the income tax department is very important and the assessee should do the compliance in time. Sometimes the assessee has in his mind that if the due date of filing the return of income has passed, and if he will file the return belatedly, then the prosecution cannot be against him. But the law is not like that. Filing of the return beyond the due date and even within the limit of belated return is not a right of the assessee, and the assessee has to explain the delay of filing the return beyond the due date if the prosecution is initiated against him. This matter has been taken by Honorable Rajasthan High Court in the case of Income Tax Officer versus Rajendra, Prasad, Vaish, and this matter has been reported in 471 ITR at page number 179. The date of the judgment is 2nd April 2024. This case relates to the assessment years 78-79, and in this case the return of the income of the assessee was quite late, but the assessee has explained the delay in filing the return of income and has duly deposited the tax on that, interest on that, penalty on that. But even then the prosecution has been initiated against the assessee. The complaint for prosecution has been filed against the assessee even without giving the notice to the assessee. When this matter travelled to the High Court, because earlier the court has given the decision that there should not be prosecution in the present case, this is not a fit case for the prosecution, but the department moved an appeal to the High Court. So the High Court elaborately laid down the law that what should be the criteria for holding an assessee, an accused, and to hold him liable for the prosecution under section 276CC. In the present case, the court said that there is section 276CC which talks about failure to furnish the return of income. It has been seen by the revenue that the officers of the revenue were not able to prove the mens-rea to hold the assessee guilty under section 276CC. So the legislature in its wisdom has introduced the section 278E which talks about that it will be presumed as to the culpable mental state, and the assessee has to prove in his defense beyond doubt that there was no culpable mental state. The court said that culpable mental state would include intention, motive and knowledge. But since in the present case the assessee has explained his case, and the Rajasthan High Court also reminded of a Supreme Court judgment. The name of the judgment is Prem Das versus Income Tax Officer 1999, and this case is reported in 236 ITR at page number 683, in which the Honorable Supreme Court said that the assessee cannot be held guilty under section 276CC without mens-rea on his part, and the court further said that only on the basis of presumption conviction cannot be done against the assessee under section 276CC. The court further said that if there are two views which are possible, then the view which is favoring the accused must be taken in consideration. The court said that in the present case no notice was given to the assessee before filing the complaint, and from the facts and circumstances of the case it is very apparent that there was no mens-rea on the part of the assessee in filing the return of income, and since the assessee has duly complied all the law, that is filing of the return, paying the tax, interest and penalty, then in this case the prosecution against the assessee does not stand on its leg. At the end of this video, once again I am repeating the name of the case. The name of the case is Income Tax Officer versus Rajendra, Prasad, Vaish, and this case has been reported in 471 ITR at page number 179 and the date of the judgment is 2nd April 2024. Thank you friends.